Okay, today I'm going to talk about something that's rather historical. And the reason I'm talking about this is I'm giving you a project to do, and it's going to relate to the circumstances that existed at that time. And the project involves a sharecrop contract. In order to understand what was wrong with the sharecrop system, I think you have to have a little background historically. So let's start off with talking about Reconstruction. So in Reconstruction, we had three constitutional amendments. The 13th Amendment abolished slavery and involuntary servitude except as a punishment for a crime, basically declaring that all the blacks who were previously enslaved were now citizens. And Congress has the power under this act to enforce the articles by appropriate legislation. And we'll see that they attempted to do that, abolish slavery, and so there are certain things that are implied in that. So we'll also look at the 14th Amendment. And the 14th Amendment is the amendment in the Constitution that is most heavily litigated. And that's because it is very packed with rather interesting clauses. The five clauses of the 14th Amendment are the Citizenship Clause, declaring that all blacks are, in fact, if they're born in the United States, they are citizens, declaring that anybody born in the United States is a U.S. citizen. So birthright citizenship, rather than the previously citizenship, which was apparently based upon blood. That is, you had to be an Anglo-Saxon male, maybe, or at least a European male, to be considered a citizen. Blacks were declared in Dred Scott decision by the Supreme Court to be persons who could never be citizens and had no rights that any white man had to respect. And of course, this is an infamous decision which actually may have been a large cause of, and that kind of attitude maybe was a large cause of the war that developed. Anyway, the 14th Amendment has five clauses. The first one is the Citizenship Clause, establishing that these slaves, these former slaves, are now to be treated as citizens, same as any white person. And that actually says that in some of the provisions here. The Principles of Privileges and Immunity Clause is the next clause, and basically what were privileges and immunities? Privileges and immunities were basically thought to be, at the time, contained in the Bill of Rights. You know, the creators of this amendment stated that they, you know, as they introduced the bill and as they talked about it, that privileges and immunities were the Bill of Rights. Nowadays, we basically have incorporated the Bill of Rights into the 14th Amendment, but not through the Privileges and Immunity Clause. So basically, in the Slaughterhouse case in 1983, the Supreme Court read the constitutional provisions, read the 14th Amendment in a way to very narrowly limit privileges and immunities to the right to proceed on navigable waterways in the United States. Obviously, that would have been a silly amendment if that was the only thing that was protected by it. But there were other clauses that were used to change those, and in some ways, some of those clauses were used, I think, for purposes that the framers did not intend, and nobody's talking about repealing those particular provisions. Conservatives seem to like the fact that despite these were not the intentions of the framers, they were obviously very nice for corporations to have. And so we're talking about the Due Process Clause. So certain rights were seen as being substantively due process. And you find in Lochner and other decisions these provisions being used to give corporations rights, and these rights being denied to, actually at the same time, to slaves who were actually the ones who were intended to be benefited by it. So it's a rather strange interpretation that the 19th century Supreme Court read into these provisions. Anyway, then the fourth clause is the Equal Protection Clause, and you can understand that that has become a very important clause and is a source of a lot of litigation, not only for blacks but for actually women and gender and for other persons. Now, I'm not saying these people were intended to be benefited by it, but the Supreme Court has read it in such a way, as in an expansive way, to include women. Well, what the heck? If they can include corporations in the Equal Protection Clause, then maybe they ought to include a lot of people in there also. Anyway, so there's the Equal Protection Clause. And the fifth thing was Congress had a clause that said that it had a right, had power to enforce the articles of this article, the provisions of this article, by appropriate legislation. This is something that was entirely new, and you find it in the 13th Amendment, and you find it in the 14th Amendment, and you find it in the 15th Amendment. These all together are known as the Reconstruction Amendments. These amendments have always at the very end a provision that Congress has the power to enforce these provisions. Why is that there? Why is that there when it's not there for things like the First Amendment and the first Bill of Rights? For the first 12 amendments, you don't find this clause in any of them. That's because these provisions were meant to apply to the states. These were giving power to Congress to legislate in a way that would control the actions of state officers and officials and require them to recognize due process for slaves, recognize equal protection for slaves, recognize their citizenship rights, should have been recognized as privileges and immunity, but I said that this has largely been very narrowly confined by the reading of the Supreme Court, which was probably not a reading that would have otherwise been thought of by most lawyers at the time. I doubt there were any lawyers who would have thought that this was what the privileges and immunities were. It was basically a dead letter for them. Anyway, 15th Amendment is the third Reconstruction Amendment, and it provides for a right to vote, prohibits the federal government and the state governments both from denying citizens the right to vote based on their citizens' race, color, or previous condition of servitude. That is, were they previously a slave? Doesn't matter, they can still vote. And they're no longer a slave, they're now a citizen. That's what the 13th Amendment established. So these were rather revolutionary kind of provisions which completely changed the nature of our government. The 1789 Constitution with the Bill of Rights, I'm not talking about the 1787 one, which didn't have the Bill of Rights, but once we had the Bill of Rights, even that provision didn't advance these kinds of provisions that were protection to everybody in a state. And you had, at first, you had the Washington and his people, and the people he appointed to the Supreme Court, led by an appointee of Adams, who was actually a man who Washington had promoted, a man who had been with him in Valley Forge, as Ed Hamilton. These people who were with him in Valley Forge actually were for a strong central government, because they knew that the problem that they had of starving in the Valley Forge, their troops were starving in the Valley Forge, largely was a problem that Congress couldn't appropriate money. They had to write letters to all of the state governors and beg them basically to send money to support the army. And so Washington, I think, and his officers, his top officers like Hamilton and Marshall, and so I'm talking about Marshall here, he's the Chief Justice, he promoted the idea that we need a strong central national government. And therefore, you could say he was opposed to a strong consideration of states' rights. Madison at first was actually strongly in favor of a strong central government. Gradually he changed. I think it was largely Jefferson who turned him over to that. So he was, and you find that states' rights was probably strongest amongst the slave-owning Southerners because they worried that the northern states would eventually abolish slavery. And so that's actually what happened. And I think they have their own self to blame in that probably Lincoln and the Northern radicals would not have been able to do as much as they had the Southerners not just simply left the Union. It provided them the opportunity to pass legislation and amendments that we have today. So anyway, so the 15th Amendment is the amendment that gives them the right to vote. Now there is some people who nowadays think that we're not really through with Reconstruction. That is, there's a 24th Amendment, which was passed in 1964, forbade the requirement for poll taxes. So after these amendments came out, these amendments and the legislation that was passed in regard to them were meant to prevent the Southerners from denying the blacks the vote, and denying blacks the rights of citizenship. And they had, after the Civil War, pretty quickly developed a system involving black codes, that we call black codes, that basically prevented blacks from having these citizenship rights, that basically tied blacks to the lands of their former owners. So, you know, basically there were provisions in there, and I'll talk a little more about that later. So the 24th Amendment forbade the requirement for poll taxes in federal elections, and also was interpreted by the Supreme Court in 1966 as actually forbidding slavery, forbidding the denial, the imposition of poll taxes on blacks in the South under the 14th Amendment, actually. So the state talked about it being discrimination based on wealth. Anyway, so the 24th Amendment was passed because at that point, in 1964, the general conception was that the states in the South had not really conformed to any sort of Reconstruction, and that it had failed, and that something needed to be done, that it was long overdue. So we have these amendments for them. Now, the right to vote was, that the 15th Amendment did not give the right to vote to women, which was a sore point for many women who had supported black rights up to that point. But many of them were bitter about the fact that that wasn't included in there. But that was done for pragmatic reasons, because people believed, the people who were sponsoring it believed that it wouldn't pass if they included women as well as blacks in there. And so they thought they could get an amendment through at that time for that. So the 19th Amendment eventually gave the right to vote to women. And so Civil Rights Act of 1866, as I said, these acts all contain provisions saying that Congress can pass provisions. Okay, so the Civil Rights Act of 1866 sought to give citizens the rights that were guaranteed, the equal protection, the due process. These rights that were given were supposed to be also further promoted by the Civil Rights Act of 1866. The Civil Rights Act and the Civil Rights Act of 1871 and 1875, we'll talk about each of those in turn. Citizens under the Act of 1866 have the same right, and this is what it says in these legislation, have the same right that a white citizen has to make and enforce contracts, sue and be sued, give evidence in court, and inherit, purchase, lease, sell, hold, and convey real and personal property. So after the Civil War, the black Southerners had actually prevented slaves from owning land. They would pass laws in states that said they couldn't own land. It's amazing what they were going to deny to the slaves if they had their way. The North had treated them very well, in my opinion, because they had not treated them as most conquering armies have treated them. They didn't hang the leaders of the rebellion. They didn't confiscate their property. They pretty well slapped them on the wrist, is pretty much what it is. And to some of them, I guess Jefferson Davis was held in prison for a couple of years, and as the prosecutors thought about prosecuting him, but eventually they decided it wasn't a good idea, and that was maybe more for pragmatic reasons than anything else. Anyway, the act discussed needed to provide reasonable protection to all persons in their constitutional rights of equality before the law. So it sought to do that. basically, without distinction of race, color, or previous condition of servitude, they were to be treated equally before the law. They would be able to own property. There are interesting things, you know, when you try to create a comprehensive system, there's something that may be left out. You'll notice in here that in this particular act, there is no provision for the right to serve on a jury. And you will remember, if you've seen the movie To Kill a Mockingbird, that there were no blacks on that jury. At that time, I believe, it was still in the South, you know, even though there had been acts passed saying that blacks had a right, other amendments were made. Even though under the amendments you would think they would have that right, under this Civil Rights Act it wasn't mentioned. And so it's interesting. It's later going to be mentioned in 1864 when we come into the 20th century. After 100 years, we're going to recognize that again as one of the rights, as well as all these rights. The Act discussed the need to provide reasonable protection to all persons and their constitutional right to equality before the law. Okay, and so we actually have to go to 1968 to see a case that upheld the Act. So for all those years the Act was on the book. Largely blacks were not able really to proceed. Very few blacks could bring a case because that was a matter of money. And you know, eventually organizations arose that would collect money and help people bring those cases. So you get Plessy versus Ferguson like that. But it took some provision. An ordinary black citizen wouldn't be able to go out and hire an attorney. He would he'd be living hand to mouth pretty much. He came out of the Civil War with nothing but his freedom. No land, no property, no education. These things had all been denied to him as a slave, and they didn't happen to him. He didn't immediately acquire these things upon being free. And although there were charities that started up to provide education and care for these newly freed slaves, they were actually the target of a lot of the white supremacist organizations like the Ku Klux Klan that were illegally and unlawfully threatening, using violence to hold the blacks back. And so they would even attack these charities that were doing nothing more than giving education to the blacks, maybe helping them with their meager resources, and maybe providing some help to them that way. And so they were targets of attack, and they would be accused of being carpetbaggers, as if they were there to make money off the South, which they weren't. They were there as charities. And so you have a large amount of fake news being spread by white newspapers that developed this argument of the noble South and the rotten, corrupt carpetbaggers and scallywags who were put into office, not maybe didn't even dominate really the offices that much after the Civil War. So there was this criticism of these governments that probably was undeserved and was largely a matter of fake news. The Act discussed, we did it. So Jones versus Alfred H. Meyer Company was the decision in 1968 that upheld the Act. So basically the Act was just sitting around dormant all those years. It hadn't been really, blacks had not sought to assert it. For one thing, there was always this threat of violence from these so-called redeemer organizations. They were not redeemers, they were more persecutors. And they basically had that problem. So anyway, Alfred H. Myers eventually recognized the right of blacks to own and possess property and to be treated equally and not denied loans and not experience discrimination when they seek to buy a house. Before that, the blacks were oftentimes prevented from buying houses. So the new houses that were built after World War II, if you were a black soldier and you wanted to buy one of those houses and you went to one of those communities, they typically wouldn't let you buy them. And that was in order to maybe, to be fair, they maybe had some marketing considerations in mind. They felt that they might not be able to sell as many if they started selling to blacks. And so they would just simply tell them, we don't sell to your kind. And they could do that. despite the fact that there had been an amendment that said they shouldn't be doing that, and even a law that said that, even a legislation. So the act, this Civil Rights Act of 1866, was vetoed by President Johnson, who basically was dragging his feet on Reconstruction. His Reconstruction was part of the problem. He was overseeing the reinstallation of the former leaders of those things. There was probably, he might have thought that the middle class, the poor blacks, the poor whites, merchants and such, would take over, but that's not what happened. You wound up with a government largely of the white leaders who had been in office and controlling the South prior to the Civil War. They went back into office, and he basically did nothing about that. So he first vetoed the act, but that was the first act that was overridden by Congress. I'm talking about since the nation had began. Up until that time, no vetoed act by any president had been overridden by Congress, but this one was overridden by the radical Congress of Republicans, who also impeached Mr. Johnson, President Johnson. Civil Rights Act of 1875 guaranteed African Americans equal treatment in public transportation and public accommodations. Now that was something else, right? You don't find that really takes place until the 60s. You may have heard that, for years and years and years, blacks couldn't get a room in a hotel. If blacks wanted to travel, they would usually have to arrange ahead of time where they were going to stay with some friendly black persons who would maybe allow them to stay in their home for overnight, or they'd sleep in their car or something. Even blacks who were employed by somebody. So if you were a rich entertainer, you might have a black chauffeur, and your black chauffeur couldn't stay in the hotel with you. And that was a problem for everybody. Anyway, Civil Rights Act of 1875. Now, there was one in 1871, we'll talk about that in a minute. This one in 1875 guaranteed African Americans equal treatment in public transportation and public accommodations and service on juries. It actually guaranteed service on juries. But you see, that also was not enforced for years and years and years. Because like I said, you don't see any black jurors in that movie. But that was actually reflective of the reality of the South. Blacks were given a right to give evidence, but there was no mention of a right to serve on jury until 1875. And in this act, though, why didn't this act stick? That's because the U.S. Supreme Court declared the act unconstitutional in the civil rights case. The Supreme Court stated that the public accommodation sections of the act were unconstitutional, saying that Congress was not afforded control over private persons. So this is a support of the states' rights doctrine, that the amendments only addressed the right of states, that the states were not to do discrimination. But if that's a very narrow reading of that. It also would be a reading that says the states have no responsibility to enforce those provisions of that amendment. So that's a very, very narrow reading. That's the Supreme Court in 1883, yeah, I think it was. First act vetoed by the Congress. It may have been even earlier than that. Anyway, Civil Rights Act of 1875. Supreme Court, yes, 1883. Supreme Court declared the act unconstitutional in 1883. Supreme Court stated that the public accommodation sections of the act were unconstitutional, saying that Congress was not afforded control over private persons or corporations under the Equal Protection Act. But it was given control over states, and states could be told to enforce their laws and to treat and have and enforce their laws the same as they would for a white person. Anyway, parts of the Civil Rights Act of 1875 were later readopted in the Civil Rights Act of 1964, and then you see in the Hearts of Atlanta a case where a black went to apply to a Hope Motel in Atlanta, and when he was turned down, he was able to bring a case, and the Supreme Court declaring, yes, he has a right to stay at your hotel, has a right to a public accommodation. So if you're in the public, if you're serving the public, you got to serve all the public. You can't just say, I'm not going to recognize this class of citizens. You got to do all that. And we see it recently coming up in regard to the gay couple who wanted to buy a cake for their wedding, and that particular baker decided he didn't want to serve a cake or make a cake for a couple which was not straight. And so, but the Supreme Court said, yes, you have to do it under this act. So this is being enforced. And you see these acts have larger implications for the society. If we allow some to be discriminated against, how can we stop discrimination against others? Anyway, parts of the Civil Rights Act of 1875 were later readopted. And so Civil Rights Act of 1968 and 1964, both of them basically cited the Commerce Clause, and they didn't cite the Reconstruction Amendments, because there were precedents that said that those were not rights that they could use. So they went through the Commerce Clause. Recently, the Supreme Court has recently declared that the Commerce Clause cannot be used in that way in other cases. So we're seeing the court changing, going back and to make America the way it was maybe after the Civil War, that period from the end of Reconstruction, because there was a kind of Reconstruction that Ulysses Grant enforced. But after he was left office and there was this contested election, the way it was settled was that the northern candidate who became president had to agree to not enforce the Reconstruction, to withdraw the military troops from the South, which were part of the Freedmen's Bureau. So these were military acts that established the Freedmen Bureaus. There were 5 of them for different districts of the South, and establishing authority for the military to come in and enforce the acts. And so there was some enforcement. I'm not going to say it was perfect enforcement. The Colfax Massacre and the Louisiana riots in New Orleans happened while we had the military down there. And so the violence in the South was very difficult for the military to actually deal with. So there you have it. U.S. declared the act unconstitutional in civil rights cases in 1883 for the 1875 Act. Parts of the Civil Rights Act of 1875, like I said, were readopted in 64 and 68, and civil rights activists at that time, which cited the Commerce Clause. Civil Rights Act of 1871. Now this was the act that was meant to enforce the right to vote. The last of the 3 enforcement acts passed by the United States Congress. Now this was passed after it was shown by good evidence that there was a lot of intimidation of voters in the South, and blacks were trying to vote, but they were being heavily intimidated by redeemers, so-called redeemers. Of course, they weren't redeemers, they were outlaws. They were outlaws who were using extra out-of-the-law means to basically force their culture on the whole nation. There's a concept of culture. Anyway, passed by Congress from 1870 to 1871 during the Reconstruction era to combat attacks upon the suffrage rights of African Americans. Empowered the president to suspend the writ of habeas corpus to combat the Ku Klux Klan. So basically the Ku Klux Klan would come in there and terrorize people, and they'd be hauled into federal courts, and the state courts would issue a writ of habeas corpus, and and they'd go over to state courts where they were treated very friendly by the state judges and the state jurors, and so that's why they gave the power to the president to suspend writ habeas corpus in this act. So, so he could suspend the writ of habeas corpus, so they couldn't switch the jurisdiction. Of course, this was very much something that they contested under states' rights. In 1875, the Supreme Court struck down parts of that legislation as unconstitutional in the United States versus Cruikshank. So, you know, that was 1973, and United States versus Reese. After the Reconstruction era ended in 1877, definitely it ended, as some people would say earlier. Certainly in 1873, those cases had taken away a lot of the wind from the sails. But in 1877, the federal troops left, so it was definitely gone. Enforcement of these laws became erratic. That's not saying, I mean, that's kind of understating it, I think. I just don't think they were enforced at all. And in 1894, Congress repealed most of their provisions, so Congress itself. And you find in 1903, I think, yeah, 1903, a decision of the Supreme Court saying, even though there was lots of evidence that in Alabama the blacks had been denied the vote and intimidated and all these kinds of things, and weren't allowed to even register to vote as citizens, the Supreme Court said, well, there's nothing they could do about it. And, you know, so the Supreme Court threw up its hands and said, well, there's nothing we can do about it. They didn't attempt to do anything. They didn't try to do anything. They just kind of gave up on it. And this was pretty much common of the North's reaction after Reconstruction. Some people say that basically the North got tired of that. But, you know, one of the scholars I know who has told me that he thought that it was largely that the veterans of the Civil War had largely retired by 1877, and they had already died off, and they were no longer really very active. And so they had been supporting Reconstruction because they had fought to free the slaves. They understood the war as being a war to free the slaves, largely. Now, I'm not saying all of them did. There were obviously people who didn't think it was that. Certainly the North tried to portray it as a law about states' rights. In a sense, it was a war about states' rights because the states had been using their powers to prevent the rights of citizens and promoting instead the rights of the power brokers of the South, who were largely the planters. And they didn't want the black citizens to have any powers whatsoever. In 1870, but also any white person who came down from the North and tried to help the blacks would be subject to that. If you were involved in educating a black person, that was against the law in the South, you know. And so that may seem odd, but that's the way it was. In 1875, the Supreme Court struck down parts of the legislation as unconstitutional. So that was the Cruikshank decision and the Reese decision. After Reconstruction era ended, enforcement of these laws just basically disappeared. In 1957, Congress passed the first civil rights legislation since Reconstruction, Civil Rights Act of 1957. This legislation authorized the Attorney General to sue for injunctive relief on behalf of persons whose 15th Amendment rights, that is the right to vote, remember the 15th Amendment we talked about, on behalf of persons whose 15th Amendment rights have been denied, created the Civil Rights Division within the Department of Justice to enforce the civil rights lawsuit through lawsuits, through litigation. So there was these attorneys from the Justice Department who were, you know, sent to the South to enforce these laws. And it was really somewhat dangerous because there was a lot of opposition to it, and a feeling, I would say an outlaw kind of feeling, a belief that they could violate the laws, a belief that the law was something other than what the Supreme Court even said it was. You know, the Supreme Court up to now had been largely doing it, but here the Supreme Court had switched in '57. So you had a court that was largely composed of people who had been put on the court by Franklin Roosevelt, who was very much a liberal, and although he had never passed any civil rights legislation, the people he put on the court were in favor of the rights of persons. And so you find that these were the people who largely supported that. So it goes. So that was that. Voting Rights Act of 1965. So besides the 1957 Act, we have then a another act passed in 1965, because after you begin to bottle up one thing, the South began to look for other ways to prevent people from voting. So one of the things they would do was to make last-minute changes in voting. So they'd move the voting place to a new location, oftentimes to a location that was not likely to be convenient for blacks to go to. That is, far away from where black people lived. And they gerrymandered the districts and did other things in order to basically prevent blacks from voting. They passed laws that would require literacy tests, and so a person would be given a black person would be given a test and asked to read it, and maybe have to answer some questions on it. Blacks were pretty much the only ones that were asked to do this, and they had a high percentage of failure rates because the tests were usually very hard. There's an old joke about a black man went to vote and he was given a sheet of paper to read, and he says, "I can't read this, it's Chinese." So, well, you can't vote then. So, but I suspect that that's apocryphal, but it was basically somewhat like that anyway. Anyway, so the 65 Act actually targeted certain states and local governments that had a record of doing things like that. A lot of states would have a grandfather clause. If your grandfather could have voted before 1865, not that he did, if your grandfather could have voted before 1865, you would be grandfathered in and you could vote. There were no blacks whose grandfather voted before 1865. So it was just simply a provision where whites would just simply be right in there and wouldn't have to take any sort of test. My grandfather voted before 1865, or could have. And so that's how ridiculous it was, really. The Act created special provisions for covered jurisdictions. Covered jurisdictions were those that had previously done a lot of discrimination in voting. And so there was this pre-clearance provision that prohibited covered jurisdiction from implementing changes to their voting procedures without first receiving approval from the U.S. Attorney General or the U.S. District Court for the District of Columbia. That the changes were not discriminatory, so they had to submit it to show that it was not an act of discrimination. That meant they had to do it more ahead of time, usually giving a lot more time than they had previously given to let people know that they were even changing it. So also the Act had made tests illegal, banned tests such as literacy tests, and the bill authorized assignment of federal examiners to registered voters, and also in these covered districts, and also would send in federal observers to observe and monitor the elections, so they would know whether or not people were just being turned away by the officials there. The bill also authorized assignment of these examiners. So anyway, major amendments to the Act came in 1970 and 75, 1982 and 1992, and 2006. Why were all these amendments to the Act passed? Because the South constantly was developing new ways, sometimes with the assistance of the Supreme Court. So Congress expanded the original ban on tests or devices to apply nationwide in 1970. Okay, and in 1975, Congress also expanded the Act's scope to protect language minorities. So people who maybe only spoke Spanish or some other language would, if they were citizens, have a right to vote. And so what we're talking about here is Jim Crow sovereignty. Emancipation gave slaves a right to negotiate terms of employment. So the first thing that happened in the South was these blacks had to be at least persuaded by the owners of the plantation to work, and so they would negotiate with them. The negotiations were nonetheless very lopsided because of the codes that had been adopted. The blacks couldn't leave the land. If they left the land and couldn't show that they were employed, they'd be arrested on vagrancy, and then they'd be sentenced by a court to do labor. And that labor might be for the state. It might be working, building roads, making big rocks into little rocks, or they might be working in a coal mine that basically would pay the court and pay the state for this labor that they were receiving from that, or they could be sent to a plantation. So they might wind up back on the old farm that they didn't want to work on in the first place. So that they needed to make a deal with their previous owner. Usually was their best thing, or they had to leave, and that was difficult because they didn't have the money for leaving. You know, so traveling is expensive. You have to have money, and so they were sort of trapped into it. So some people said it was slavery by another name, and in fact, I think it was. No longer able to control the former slaves to work long hours, they faced economic ruin. So they would insist upon these slaves, the deals that they would work out would be sharecropping, where basically the slaves would get a certain proportion, and to get them, they would have to give assurances to the owners of the land that they would be able to get it in. And so you found these black families pledging their whole family, the children and the wives, everybody would be out there in the fields working during the season to harvest and plant the cotton, even though there were long hours, just as they had before. And so there was some improvement in their situation, but I mean, theoretically they could leave, but as a practical matter, most of them found that they couldn't leave. And so there were problems with that. And so basically the black plantation owners devised a caste system that allowed them to keep their old arrangement in force. Outlaw bands, initially that was done by violence, obstruction and violence. You know, so this was the so-called Redeemers, the Ku Klux Klan and other white supremacist groups that would, you know, terrorize the blacks with illegal acts of mayhem, murder, and torture. Outlaw bands, Ku Klux Klan, so-called Redeemers, intimidated ex-slaves, federal officials, and charities. So if you were a person who was in the South, pursuant to federal law to enforce the laws, you would be terrorized. We see this also when in the 1960s students went to the South to participate in the marches and the demonstrations and the sit-ins. They were oftentimes, some of them were kidnapped and killed, and so they were terrorized. So that's how it was, kind of a violent, self-righteous society which thought it knew better than everybody else. Outlaw bands, so they intimidated ex-slaves, officials, and charities. White newspapers, as I said, fabricated fake news, creating the false image of the newly integrated state governments that had some blacks in them and had some, maybe some northerners who had migrated to the South. And basically these were, you know, characterized as being incompetent or corrupt. And, you know, and this was used as an excuse to keep blacks from voting. So, well, if we give them the vote, they'll just elect people that are incompetent and corrupt. And it was largely a lie. Eventually the army was withdrawn, you know, which was a result of, like I said, the 1877-78 election. The army was withdrawn, and as the Southern, and in some ways the North didn't protest too much, but the soldiers who had fought for the removal of the oppression were pretty much getting too old to really complain, and you know, and there was all this propaganda put out by Southern newspapers and others about how it was. And it was even in the history textbooks. As a matter of fact, as late as the 60s, that was true. It certainly was true of my history textbooks. You know, there was a page in there that talked about the scallywags and the carpetbaggers. And there was no talk about the corruption. There was no talk about the Colfax massacre or the massacres in Louisiana, the so-called Louisiana New Orleans riots, which were really riots where large groups of whites were terrorizing blacks. And this was never mentioned. And states' rights and black codes. So the defeated leadership of the South refused to recognize all federal authority except for that enforced by the occupying federal army, which was not adequate to deal with the violence. Eventually the Army was withdrawn, and a Southern propaganda campaign convinced enough Northerners that the corruption and failure of the federal reconstruction efforts, and the leaders of the rebellion regained that control over the southern states, and then they passed laws that were meant to control the former slaves, forcing a de facto slavery. That's another name for slavery by another name. Okay, vague laws were on the book that enacted, for example, vagrancy laws. Who's a vagrant? Somebody who hasn't anything to do. He's just walking around doing nothing, apparently. And you say, well, you're employed. Now, if he doesn't have a job and he says he's not employed by anybody, if he can't produce an employer in court who says, I've employed this man, then he can be sent and fined, and he can't pay the fine, then he'll be sent to prison and made to work either for the state or for somebody who pays the state for his labor. Anyway, and he doesn't get anything of that pay. So, you know, that's how that system worked. And so these were pretty much kangaroo proceedings, we would call them. Okay. Let me try and wrap it up here. Supreme Court decisions, there were a number of decisions. Civil Rights Act of 1875, held unconstitutional in 83, we mentioned that. The 14th Amendment was also held to be a dead letter by Harris decision in 1883, which declared that Congress had no power to interfere with the police powers of the states. So that's states' rights, and that it confirms the state action doctrine. And that was the Morrison case. And this was, this was actually confirmed in a recent decision called the Morrison case, the United States versus Morrison in 2000, which confirmed the state action doctrine. Courts today seem as little concerned about the rights, or the present Supreme Court seems as little concerned about the rights, and a lot of the judges seem very little concerned about the rights of these amendments. And so we also have now a Federal Hate Crimes Act, which was passed, that criminalized bias-motivated assaults, which could have been used against the Ku Klux Klan and others. But I don't see any future in hate crime statutes in this country. I think they're probably not going to be held valid, and because they're rather vague, if you get right down to it. And so there is that act that was passed.